Hello, this is Jatin Popat, Director, LegalJini.com. We have started a campaign on will. We understand that in India, will is not being made regularly by people. People skip making a will, and it makes a difficulty for family for distribution of the property in future after the demise of a person. We understand that wealth planning insurance advisors, they do meet people and they explain about the wealth planning, the making of contracts, making of their investments, many areas. However, the will is a final step where a person, when do a financial planning, they do invest money as per the advice of the wealth advisor, insurance advisors, banks, financial institutions, and after making investments, the ultimate goal of any person is to make a family very happy during their lifetime and even after the demise of a person. So insurance policies, shares, debentures, bonds, bank FD, PPF, all these things are being accumulated during the lifetime of a person to become a wealth. It includes flat, land, offices, gold, silver, lockers, many things. However, if those items or those properties are not being distributed properly after the demise of a person, it will be a not correct situation for a person. There are instances where people, when they don't make will, the family gets confused how to distribute within them, because there is no instruction given by a person to distribute it. Many a time people take insurance from the age of 30 and they feel that even death can arrive at the age of 30. So there is no age bar or age limit someone can say that one will not be available for the family. Hence, it is necessary that will has to be made during a lifetime at any age. Like insurance can be taken any age to provide fund or financial help to the family. Similarly, will is a instruction given in writing to a family that whatever property insurance claims funds received after the death should be distributed as per the wishes of the person who actually owns. If there is no will, then the properties and asset will be distributed within the family as per the Hindu Succession Act or Indian Succession Act applicable to the particular persons, whether of his religions. As per the Hindu Succession Act, if person is died, the class 1 heir, which include wife, mother, the sons and the daughters, it is distributed equally, right? So even if you don't wish to give your property equally, it will be distributed equally since you have not make a will. So it's basically a very interesting thing to note that there is a myth in the people's mind that if I have not make a will, it will be given it to my wife fully. No, it's not like that. It distributed equally with the wife, your mother, your daughter, son, as per the class 1 heir definition of the Hindu Succession Act. In other religions and other people also, there is a succession law where under which there is no will, then person is called intestate, and hence the property is distributed as per the law, not as per the wishes. Now, how and will can be made? That is a question generally people ask. Whether any stamp paper to be bought, whether to be consulted a lawyer, whether the will has to be registered, whether it should be typed, whether it is own handwriting, all these questions are there. Basically, as per the law in India, the will can be made on plain paper. There is no need to get a stamping done or any stamp paper required. Will can be made in own handwriting, will can be typed also. Will should be in as simple as language possible. However, one should avoid vagueness or contradiction within the will, Otherwise, there could be a misinterpretation or misunderstanding between the family, and they may again fight even though there is a will, because it is not been correctly drafted. Hence, sometimes it may be good to consult a lawyer or a qualified person who can guide you to draft a will in accordance to your available properties. Many times people mention in a will about the properties which are not fully owned by them. Some property are jointly owned, some property where they have invested money but it is owned by the wife or son or daughter. Those things one cannot make it in a will, because the will has to be made of your own property. You cannot bequeath or give in your will the properties which are not fully owned by you. Hence, for that matters, yes, you may consult your financial advisor or a lawyer or a chartered accountant who can guide you basically which are the things one should have. Whenever you make a will, it is good that it is typed. If it is in handwritten, yes, it is accepted by the law. However, when you make a will, it is necessary that you should sign in the presence of two witnesses. The witnesses has to be present when you sign it. Preferably, they should be of a younger age to you, and they should not be beneficiary in the will. So, person who is getting something from the will or their relatives, close relatives, should be avoided. We suggest and advise that witness should be near to your. It could be your friend, it could be your chartered accountant, it could be your doctor, it could be your lawyer, and who can vouch for you when there is a problem. They should come to the court when there is asked whether the will is genuine or not. So those are the people who are actually your family friend, and you believe in them, you have a trust. So basically, they should be there when you sign a will. To make a will, you should have age of 18. You should have a sound mind. You can have a physically able to read and understand your will and sign. Even will can be made in a regional language which you understand properly. However, when you go for registration, the translation may be required. So when you make a will, it can be in any regional language, it can be own handwriting, it can be typed. However, it is to be signed when in the presence of two witnesses. That is important. Now, after making will, whether the registration of a will is mandatory, it is not mandatory. As per the law, will is optional, and you can register it anytime during your lifetime. It is not necessary that you should go within 4 months like other legal documents. The registration has to be done nearest to your home where you live, and you have to carry with you original will, medical certificate, preferably by the MBBS doctor of current date, which says that you are physically and mentally fit to execute such document. You should carry with you your address proof within that locality where you have gone for registration. There is no fee for the registration except some scanning document or those basic administrative costs of the registration office. After you make a will and register it, whether the registration office keeps with them or you hand over to you back. After registration, generally wherever the cities it is electronic things has been started, the original will is given back to you, and the government keep a scan copy or a soft copy of the document in their records. The original will is returned to you, which you can keep in your safe with yourself. You can give it to your lawyer, your friend as a safekeeping, so that in case in future when you are not there, the will is available to your family for the right purpose. So will can be kept anywhere. It can be in your locker, it can be given to your bank as a custodian, it can be kept in your other property documents, so that it can be seen and received by your family if you are not available, so that there should not be misunderstanding whether there was a will was available or not available. It is not necessary for you to show your content of the will to your witness. Okay, witness should sign that you are signing in their presence. So reading of the whole content, witness may not be shown actually. In your will, it is better to keep executor of your will. The executor is a person again who could be a well-wisher to you, who knows the property matters, who can be your friend, who can be your chartered accountant or a consultant or your family friend, who can help your family to distribute your wealth as per your wishes. So executor can be your family member, who like your wife, your husband, or your outside person who has a good family friend. Executor again may or may not be informed that he has been executor. Preferably you want to inform that I have made a will and I have made your name as executor. So executor is aware. He should not know what content it is there in the will. So executor or witness, it is not necessary to tell them what you have written in a will. It can be secret. It can be secret for you. However, when you register the document as a will, again, this is not a public document. Except you, no one has any access, or they can take a copy from the registration office when you are alive. After your death, yes, it becomes a public, and your beneficiary can go and they can take a copy from them by showing the necessary proof. How the executor will take it? After your demise or death, the executor will go through the will and he will inform, he will call the people who are named into it so that they know the will is there, what are the wishes of a person who is kept a will. Once they know, then the executive will start his action to distribute the properties within the family, and it is to made in such a way that the wishes of a person is been fulfilled, and hence the happiness to the person who is demise, happiness to the family continues, and there is no misunderstanding or fight between the family. Now after making a will, maybe there is some changes you want to make. How to do? There is a process called codicil. A codicil is a very brief document similar to will, where you have to mention which are the property you want to include or delete, or you want to make any small changes in your will. Many times people, they do make their will again after after passing of the gap of 3 years or 5 years, so that any new property or any family changes are being included in the new will. It is always better to revise your will after 3 years or 5 years. There is no time limit. You can make as number of will as you wish. So whichever is the last will survive. The statement is always made in the will that this is my last will and all the previous will gets cancelled. Hence, you can make will as many number of times as you wish. I understand that somebody in past has made 55 wills. He had a hobby of making wills. So that's fine. The court and the India government and the family, everybody has to respect the will as a final document, your wishes. There are instances where people they don't make a will and they miss, and how and what affects the family is one has to understand. If you don't make a will, the family doesn't know what was your wishes. They start getting confused. There could be a misunderstanding. There could be a fight. And when they go to the court, the property is distributed equally with class 1 heir as per the Succession Acts. So it's necessary that one has to make a will which is not that costly, which sometimes you can make a free of cost sitting at home by, if you know subject well, you just call 2 witnesses, make your will where you mention that you are fit and fine, what is your health status, what is your family, mention that this is my last will, you mention your family details, mention your property details, and you can mention that how you want to distribute. You can mention details of executors, mention the details of witness, and sign all the pages of the will. Let witness sign all the pages of the will. There has to be 2 witnesses, this is must. And that is how one can conclude a will nicely to make the family happy forever. Even the person who has made a will becomes relieved that yes, my family will continue to be together even after his demise, and his wealth and properties are handled in a perfectly. Thank you.